इस सुनवाई में आप देखेंगे कि किस तरह से लैंड रिकॉर्ड यानी ज़मीन के जो दस्तावेज़ हैं उनमें नामकरण होना इम्पॉर्टेंट है और उसमें किस तरह की बाधाएं होती हैं, ये सुनवाई उन मामलों के ऊपर प्रकाश डालेगी। तो आइए देखते हैं क्या है पूरा मामला और क्या है सुनवाई।
रिकॉर्ड हाँ है।
The order which challenged before my lords is at page 9.
Who are you?
I am, my lords, the landowner.
Landowner.
My lords.
What brought you to the writ court?
There were, my lords, the acquisition proceedings, and earlier also when the acquisition proceedings were going on, without following the procedure prescribed under 2013 Act, the petitioner challenged it before the civil court, got a decree in his favor, my lords, that is affirmed by my lords in the second appeal, and thereafter, my lords, the subsequent round of acquisition proceedings are now going on. My name is not there in the revenue records, so I filed an application for seeking correction in the revenue records. Now, owing to my name not being in the revenue records, the disbursal of compensation proceedings which are now going on, I will not be receiving compensation, because when I filed an objection before the authority who is conducting the land acquisition exercise, he outrightly, my lords, dismissed my objection, saying that your name is not reflected in the revenue record. Though, my lords, in the civil litigation I have satisfied before the civil court, as well as my lords have affirmed this, that I am the landowner of the particular land. Now, my lords, I came with a prayer before the writ court that my application seeking correction of revenue entries is pending before the learned subdivisional officer, and as per section 115 that may be decided. Now, my lords, that has been because if that will be decided, everything rest will follow up, my lords, that I'll get the benefits. Now that has been decided, my lords, and order is at page 10 and 11, the operative portion. May I read, my lords? My lords, at page 10, 1, 2 and 3 are my prayer. Thereafter, it is submitted by the counsel for the petitioner that the petitioner has filed an application under 115, 116, read with 32 of MPLRC for mutation of his name on the basis of partition. The said application is pending from 12/5/22, and since the land in question has been acquired and there is every possibility of distribution of compensation amount amongst the landowners, therefore the SD of Vidisha should be directed to decide the application as early as possible, preferably within period of 1 month. It is further submitted that the three brothers, including the petitioner, had filed a suit against Municipal Council Vidisha, which was decreed by the first appellate court, and the second appeal filed by Municipal Council Vidisha was also dismissed. Then therefore it is clear that petitioner and his two brothers are the owners of the land in dispute. However, the name of Dayashankar, one of the brother of the petitioner, is mutated in the revenue record, and therefore it is necessary that the name of petitioner should also be mutated in the revenue record. During the course of argument, it was found that the legal representative of his late brother and the third brother have not been impleaded as respondents. Section 1152, now this was my submission, though it has not been recorded, so 1152 of MPLRC also requires that the proceedings can be decided only after issuing notice to all.
अरे देखो, जब तुम लोग कितनी बार बताएं, impugned order पढ़ना is a very sacrosanct duty. Don't read it in such a cursory manner. You are not doing the formality by reading the order. You are trying to make us understand where the legality has crept in. So don't be so casual while you are reading the impugned order or impugned letter or impugned communications, because you have to point out where the legality has occurred. Now read again page 11. Section 115.
Section 1152 of MPLRC also requires that the proceedings can be decided only after issuing notices to all the interested parties. The counsel for the petitioner could not point out any reason for not impleading all the interested parties as respondent in the application. Be that as it may, since the application which has been filed by petitioner is not complete and has been filed without impleading all necessary parties, this court is of the considered opinion that at present no case is made out for issuing any instructions to the SDO.
You implead them and you will put.
I'll do that within 7 days.
totally innocuous petition. This could have been done by writ court also. That SDO will proceed after implement of necessary parties.
Transfer allotted on 12/5/2022. Application is moved before the.
So it is not even a year. Now, if there is some amendment required, it should let us give him liberty to move an application for amendment and
What the concerning?
authority. WA number 930 of 22. Petitioner is styling himself to hold the title of land in question along with his two brothers by virtue of a judgment and decree dated
That's dated minutes. 20th of October 2015.
stop. The same as attained finality. Stop. In the revenue record, the name of one brother, namely Daya Shankar, is recorded as owner. Stop. But petitioner's name and that of the LRs of the deceased brother have not been recorded. Next, petitioner appears to have moved an application. Next one, appears to have moved an application seeking mutation in revenue record under section 115, 116, read with section 32 of the NPNR code. The application is pending consideration. Stop. Petitioner approached the writ court under Article 226 seeking an innocuous direction to the SDO. SDO?
Well,
It should go to Tehsildar.
it is for correction of the revenue entries. I filed it before Tehsildar.
So mutation of the correction. क्या लिखा है लास्ट में क्या है seek relief for direction to the SDO for correction of the entry. That application filed before the SDO array necessary parties, that is the other. Hence, application was found to be application since was found to be incomplete, therefore declined to as sought for. Next, that he is prepared to implement the LRs of the deceased brother as respondents within a week from today. Hence, direction may be issued to the SDO for expeditious disposal of the pending application. Stop. An urgency is involved as the land in question has been acquired by the land action officer. Stop. Stop. Payment of compensation. Process of payment of compensation. If petition is disposed of with the aforesaid liberty, accordingly, W is disposed of. Sorry, appeal is disposed of. Accordingly, W is disposed of with following directions. Petitioner may move an application for implement of necessary parties pending unfiled under 115 read with 32 and pending for the SDO. Stop. The SDO is hereby directed to issue to allow the application and order for issuance of notices to newly added respondents. So after service of notice, the judge shall decide the application in accordance with law expeditiously.
But if after service of notice, any time bound period can be after service of notice.
Shall decide in law within 1 week from the date of service and appearance of the newly respondents in person or through. Within 2 weeks from the date of service and appearance. Service and appearance of respondents, newly respondent in person or through the consul. Within 15 days. It is made clear this court has not expressed any opinion that that's the case.
Price.
Yes.